courage and vision. And therefore, as we reiterate our commitment to struggle and celebrate the end of dark times, we can see a ray of hope in our honorable speaker. I invite President of BUCL, Kavita Srivastava, to come on the stage and take us. I invite the General Secretary, P. Suresh, to come on the stage. I invite the Vice President, Advocate Mihir Desai, to kindly come on the stage. And I invite our speaker, Justice Oka, to take us.
Everybody, I welcome all of you once again on behalf of the National BUCL to this 45th Memorial Lecture which we do every year in the name of Jayaprakash Narayan. Since there's several young people, let me tell you why we do it. It's actually done on the 23rd of March, but due to date adjustments, we moved it to the 30th. But why the 23rd of March? 23rd is remembered for several reasons. It's the Shahadat Day, Martyrs Day of Bhagat Singh. But it's also the day when Indira Gandhi, after having lost the elections in 1977 on the 16th of March, signed away the emergency. Now the emergency has been withdrawn. But that was done on 23rd. Democratic rights. Many people are aware of it. So in a way, this human rights movement is 50 years old. In 1976, it actually, formally born. So we are in our 50th year. It was envisaged by Jayaprakash Narayan as an organization where all those committed to the defense of civil liberties and democratic rights, whatever be their political ideology, whatever be their vision of the economic institution suitable for the country, they would try to bring together everyone on one platform. And it also saw equality amongst everybody and said that even people of political parties can be in this organization, and today we stand with that. And it's important because, as we know, during the emergency, the entire opposition, all those who were dissenting, were thrown into the jail, and today also we know who are those who are silenced first. Those who are dissenters and those of the political opposition. So friends, the important thing about this organization is also that Justice Oka very much from the Bombay High Court, was its first president, and post-emergency, after 1977, this organization was revamped, and what we call the People's Unit for Civil Liberties was born in 1980. I'll just very quickly take a few more minutes to tell you why it's important to recall some of our objectives. One of the main objectives of this organization is to uphold and promote by peaceful means civil liberties and a democratic way of life throughout India. This is at the core. Some of the other aims and objects which is important to, in a way, look back and see is to continuously review all the penal laws, criminal procedures, and bring them in harmony with humane and liberal principles. Today, when we are in an era of undeclared emergency, the PUCL has been calling it that for a very long time. We know what kind of law Freedom of Conversion Laws, Disturbed Area Act, you have the Public Safety Act, the UAP, and many more. So we have to work for the withdrawal and repeal of these repressive laws. Our aims and objects say. It also says that at any cost, encourage freedom of thought and defend the right to public dissent. We stand for that. To ensure freedom of the press and independence of the mass media. And then, of course, to secure the rule of law and judicial independence. I'm sorry to say, we're doing this lecture in an era where we feel the judges, at least in the Supreme Court, the top level, seem to be executive-minded. They really don't care for justice for the people, or really don't care for the Constitution. We fearlessly would like to state that again and again and make them accountable. The PUC also works towards the reform of the judicial system so that you remove delays and other expenses, etc. Prison reform is a very important agenda. Of course, police excesses has been at the core of our work, because we know the kind of torture and now the kind of torture doctrine that has emerged, that we just saw what happened with the students in Delhi. It's actually something that we have to take on even now, and of course finally do all acts necessary that will help to achieve all the above aims and objects. So friends, welcome once again to this particular evening lecture. At the same time, we would like all of you to also be associated with the PUC. I'm not doing any marketing, but we need everybody today to defend our civil liberties and democratic rights. Thank you so much, and Justice Oka, welcome once again. This is really a privilege for us to have somebody who's so fearless talking to us. Thank you.
My name is Suresh. I'm the National General Secretary of the PUC. I come from Chennai. I'm really practicing in the last time. It's my duty to share with friends here our joy of coming back to Bombay for the JP Memorial Lecture almost after 25 years. The 23rd of March 1977 was the day when Indira Gandhi was forced to withdraw emergency and declare elections to take place soon after. Many of us here know that in the very dangerous period of 75 to 77 and the year before 1975, 26 June 1975, Jayaprakash Narayan leading the movement of young people, especially all across the country. Sampurna Gandhi movement, we had the students movement, we had the youth movement, all across northern, central part and western India. That is the impetus which forced Indira Gandhi to declare emergency, apart from several other reasons. And he became a unifying force to bring people together to fight the extremely draconian administration of that period. Of course, if you look at that administration and the emergency of that period, and you look at the undeclared emergency of this period, there's a whole world of difference at stake. Nevertheless, it is in this context that we need to talk about human rights. And it is in this context that, in honor of JP, soon after he died, PUC have decided that we will celebrate March 23rd as JP Memorial. Generally, we stick on to March 23rd because that day is very symbolic. It's symbolic of the possibilities of citizens coming together, not necessarily under one political banner or under political, but as a broad-based platform of citizens wanting to bring about change in authority and regimes, bring them to accountability, and seek justice for the various violations that are taken place. And based on the understanding that it is not just one institution which is responsible for emergency, there are several other institutions which are also equally to be framed or become party to it, which we also, from that time onwards, have been focusing our attention, looking at a variety of these institutions that have been taking part in. So that became the basis for a lot of hard work over the last 40, almost, this is the 50th year since formation. We will be starting celebration for the 50th year from this year onwards till next year. It is an occasion to remember that behind 23rd March 1977 was the courage of ordinary people to come together to declare that we will not remain quiet. I think that is what exactly is wanted today. And through the JP Memorial lectures, we seek both to reignite the emotional context of what JP stood for, and also to have people who will give forward-looking lectures, which will also in a way give us an occasion to rethink some of the situations that we are in we talk about. So over the last 45 lectures, all these lectures are available, barring about 4 or 5 in between. Many of them are available in the website. We also have brought out a book of these things. So I would advise, I would request many of you, if you want, please to write back to the museum. We will be very happy to share with you. Some of these things are extremely important and valuable documentation of the human rights movement in the last 50 years. We have had a long range of very many people who have given lectures. We've had Nivedita Menon giving a lecture in 2013 in Bombay. We have had Ravi Nair last year. We've had the Dalit poet, very famous poet, Bhava Rangvanshi, and a human rights activist giving a lecture 2 years back. We've also had Michael Swart, a very prominent Israeli lawyer of Jewish origin, who has been taking up issues of Palestinians in Palestine and fighting for that. He delivered a 2021 JP Memorial lecture. We've had Anuradha Basim, who delivered the UCL, the JP Memorial lecture, and today she's in a very, very frequent situation. She's out, she went out for a conference and for a fellowship, unable to come back because the state has filed numerous cases, including of arms and explosives and other things against her. She's not able to come back now. So she's out there. She delivered a lecture 2 years back, 2 years after the Kashmir, Article 370. Shed a lot of light on what is actually happening in Kashmir. So the way the JP Memorial lectures work is that it is organized every March in some part of the country. So we made it a part of our policy that the lectures are held both north, south, east, west, also in central India. So that every year it goes to different parts, and we follow a certain internal pattern in terms of the choice of topics that we call our speakers to speak on. So in this context, that it's our pleasure, sir, that you readily agreed to come to deliver this lecture. Justice Oka had some other engagement for the 23rd, and therefore it got shifted to the 30th. But we are very eager to talk, to listen to him. Because as an outstanding person, his judgments speak for themselves. He doesn't need to speak about the judgment. The judgments themselves are a repository of his vision of how it should be. But even after he left, on the day that he left office, the lectures that he gave, a very self-critical review of the functioning of the judicial system, are something which may have inspired many of us to look into the type of challenges that we are now facing. Because the citizen is finally left to go back to the main place, and the only place now to demand for justice, which is in the judicial system. And the judicial system is on the tops in a way, speaking. And many of what you have said and written, sir, gave us a lot of inspiration and a lot of insights into how these internal things are happening. We're very happy that you agreed to speak on reclaiming justice, bringing back the constitution and the people into the judiciary. How do we bring back these things? That's an extremely important part. It reminds us of what Ambedkar said on the 29th of November 1949 when he talked about constitutional morality. In a land, in a soil which does not know what democracy is. So that was the vision of people like Ambedkar. And I should also mention that in the context of what's happening in Iran, of our constitution makers who discussed and debated in the Constituent Assembly, that the future India would be an India which also talks about world peace as much as it talks about development in India itself. This is the vision which our constitution makers had. And Ambedkar finally said the constitution is only as good as the people who implement the constitution. Ultimately, it comes back to us citizens to implement it. So it is in this context, sir, that we are very happy that you have agreed to come to speak to us. We are all looking forward to hearing you speak on this topic. I will now invite Nihir to
Justice Oka gave us book. I can say with reasonable confidence that possibly the best judge I have appeared before. And it's a pleasure. He joined the bar in 1983. In 2003, he was elected as a judge of the Bombay High Court. In 2019, he became the Chief Justice of Karnataka High Court. In 21, he became a judge of the Supreme Court, though many of us felt that he should have become much earlier. And finally, on 24th May 2025, he retired. He spends his time, he's taken a conscious decision and he doesn't want to do arbitration. He's not going to do any arbitration at present. He's very keen and he's already doing teaching in various colleges. And that's where his passion lies. Just to give a few examples, and please note these are very few, of the kind of judgments Justice Oka has passed. I remember when he was in Bombay, he passed an order saying that so what if according to the government or the corporation, certain slots are illegal. Even if they are illegal, you have to provide water to them. Drinking water, drinking water. That's one. The beef man case, despite, there was already Supreme Court judgment, so within the contours of the judgment, you have to make a way out. And he said that what you want to eat is your problem. You can't stop people from eating what they want. So second, a teacher was suspended because he refused to fold his hands during a prayer. And Justice Oka said nothing doing. If somebody wants to be a non-believer, then it's that person's choice. You can't suspend a person because that person is a non-believer. As far as environment goes, all of us keep on hearing day to day about going to the High Court for taking permission to cut mangoes, which nowadays High Court is very easy. But the requirement to go to High Court for cutting any mangoes is something which was brought in by a judgment of Justice Oka. And he said if you want to cut any mangoes, you come and take a permission. You can't on your own go around cutting mangroves, etc. That is something which he did. He also passed the Supreme Court a judgment by which post facto environmental clearances were held to be illegal. That you first start your project and then you take environmental clearance, sorry. You can't do that. Of course, unfortunately, that judgment has been subsequently set aside. The Melghat case which is going on right now here, the malnutrition case, the initiation of that case in Bombay was done by Justice Oka, supervising how right to food, etc. Right to food, malnutrition, medical aid, etc. That was again Justice Oka's initiation. Manual scavenging came down heavily against manual scavenging in Pandharpur, etc. I remember at that time we had appointed two lawyers and asked them to visit Pandharpur when the actual yatra takes place, make a report, and on the basis of that report and on various other things, he issued a slew of directions. Prison riots concerning prison reforms. He came out with a judgment when it was gave a judgment when it was in Supreme Court, saying that even if a marriage is declared to be void, the woman is entitled to permanent alimony. He also came out with a judgment. He delivered a judgment in Supreme Court, giving Anganwadi workers gratuity. He also, in a number of matters, when he was in Supreme Court, there were demolitions in UP, in Uttar Pradesh. He directed 60 lakhs to be paid to the persons whose houses were demolished. He struck down the judgment of the Calcutta High Court, which said basically, which Calcutta High Court judgment says that adolescent girls need to control their sexual urges. That's what the Calcutta High Court judgment said. Justice Oka said, sorry, this is not our job. Moral, this kind of morality is not the job of judges. Please keep away from this. Freedom of speech and expression and right to protest. When he was in Karnataka High Court as a Chief Justice, he set aside restraints on right to protest imposed by the government. This was during the CA NRC protests, and he struck down those restrictions which were put on right to protest in the Karnataka. Supreme Court, he said that somebody was, when Article 370 was abrogated, a person had written on his Facebook or something that this is a black day of jail, Article 370, and he was charged with sedition, etc. The matter went to Supreme Court. He said, what is this nonsense? Anybody can criticize if they want to that Article 370 is wrongly abrogated. You are entitled to say that. You can't be charged, you can't be punished, you can't be prosecuted for this. That's the level. He, on bail jurisprudence, tremendous. There was a time when the Supreme Court said that in UAPA matters, jail not bail is the rule. And Justice Oka gave a judgment saying that sorry, even in UAPA matters, bail not jail is the rule. It's not that principle doesn't go away. Similarly, when bail conditions were put, saying that you must track the person who has been given bail, the police must continuously track that person, or it should be available for tracking. Justice Oka struck down that condition, saying that sorry, this is violation of right to privacy of a person who has been given bail. You can't follow him, you can't do all this constant tracking of that person. That's not something which is permissible. Similarly, under UAPA, he interpreted Section 38, Section 40 of UAPA in favor of those who have been wrongly accused of those crimes. I can go on and on, but I don't want to because they are not come here to hear about him, but to hear him. So I will stop here, but I can only say that he is one person, both in respect of civil as well as criminal, both in respect of civil political rights as also in respect of socio-economic rights. In respect of all that, a slew of judgments which have been passed by him. Right from the time he was in Bombay High Court, Karnataka High Court, I remember Bangalore lawyers phoning me up saying that, wow, who are you saying to us? I said, yeah, I'm sorry, I think sent it to you. You should have been here. So that was I'll stop here and I'll let Justice Oka now take over.
nice meal. Dignitaries on the dais, members of the bar, and friends. The subject you are so interesting, reclaiming justice, bringing back the constitution and the people into the future. When I was contacted for this lecture, I decided to say yes immediately because of the subject, and second reason was it was in the memory of great Prakash Narayan. When Sampurna Kranti movement started, he started I think 73 or 74. I was like 30 years old. Fortunately, I was born in a family where my parents had made it compulsory to read one Marathi newspaper and one English newspaper. So I was reading without understanding the movement which Prakash Narayan did, and he became a youth leader of the youth. And then, of course, in 1977, he kept on reading about his ill health. This lecture gave me opportunity to revisit Prakash Narayan. And I realized that people of my generation, whatever it is, we knew him as somebody who led agitation against the then Indira Gandhi government. But I have not studied the other parts of the great work done by him. He was fully a Gandhian. He was a colleague of Novaji Bhavik. And I found from his writings, his speeches, that he was a strong supporter of non-violence. Normally, I don't believe reading quotes in my speech. I don't have a speech, I have only points at it down. But for the benefit of many young people I see, I want to quote what Prakash Narayan said about non-violence. And after reading that, I have read it is relevant, so relevant today also. What Prakash he said that our means of peaceful settlement, like negotiations across the table, good offices, adjudication, arbitration, friendship march, and similar methods may succeed or may fail. But there is no failure for a people who have accepted non-violence and have prepared themselves to resist whatever evil that might come with non-violence. I wrote in few lines such a beautiful message of non-violence, and the last sentence is quite thrilling for me. That who accepted non-violence and have prepared themselves to resist whatever evil that might come with non-violence. So there is much to be said about Prakash Narayan. When I was reading about him, I felt that I think he should have continued in active life for at least 10 years. Because perhaps what he started in 1973-74 in Bihar was incomplete, firstly because the emergency was declared, and secondly because he had to figure it out. So perhaps active life for 10 more years would have seen perhaps a different India. That did not happen. Now let us come to the topic today. In one sentence, the topic is, where do we see judiciary today? And this has to be in the context of Constitution of India, because after 26th of January 1950, all courts started functioning under the Constitution. And as we know, Constitution guaranteed justice, social, economic, and political. And I believe that the guarantee given by the Constitution to our citizens of justice, social, economic, and political, that guarantee can never be fulfilled unless our courts are able to deliver quality and expeditious justice. Today, of course, I am going to express my personal views, as my judgments could be wrong, these views may be wrong. But one thing which I have consistently said by our judge of the Bombay High Court, our Chief Justice in Karnataka, that
To an extent, judiciary is facing crisis of credibility. And I have repeatedly said this, that when the courts in India started functioning under the Constitution, the common man, the citizens of India had great expectations from this legal system. And somehow all those expectations could not be fulfilled by our judiciary. And of course, we have a similar, I said so on public platform, even when I was a judge, that somehow after the Constitution came into force, those who are associated with judiciary, the judges, the lawyers, somehow they kept on saying, or they kept on patting their own backs by saying that judiciary is the last resort for common man, etc., etc. I never believed that, because I always felt that if somebody is to say that common man has great faith in the institution, it should be said by persons who are outside the system of judiciary, not the lawyers or the judges. And of course, I have criticized the judiciary. I have said what two things are done by the judiciary. And I must say that when I criticize where the judiciary has gone wrong, I was a member of the judiciary in 3 different courts, say for 21 years and approximately 10 months, long time. So of course, when I say that we were not able to fulfill expectations of common man, I must also take responsibility, because I can't run away from that. As individual, I was part of that institution, and I can't stay and claim that I did something different. That's not proper for me. I was part of that institution, so whatever is the blame, if people want to blame the institution, I must share that. Few things which I want to say in the beginning. To an extent, I am eternal optimist, and therefore I want to begin by referring to certain aspects on which judiciary has done well, may not be in the immediate past or may not be today, but in the past. Instance number 1, prison justice, which was all started by Justice Oka. There was a justice contemplated in the preamble, but thanks to Justice Oka, they got concept of social justice, which is different from justice, social, economic, and political. Labor jurisprudence, the triple test in manual water supply, judgment of the bench by of the Justice Oka was part, the triple test. Of course, now it is referred to larger bench for witness to see what happens for the larger bench. But as a student of law, I must read and read that judgment. And a very interesting thing which I read some long time back was in 1982-83. The government brought about amendment, Government of India, Central Legislature, which provided for definition of industry for considerably giving narrow scope to definition of industry, but that amendment was never brought into force. And one thing I always say is about Keshavananda. Surprisingly, the origin of that concept we borrowed from the British and Pakistan. This is spontaneous, which was followed by Justice Oka in minority insurgencies case. I personally believe that this is one case, Keshavananda, because of which India stands on different footing than our neighbors on left and right side. On a great extent, it saved us, it tried to save the Constitution. And then environmental matters. Of course, many of you will say that what Supreme Court has done in environmental matters, maybe now there is a change of or shift of approach. Maybe now we are moving in backward direction. That or not. Please imagine what would have happened if there were no Godavari, if there were no MC Mehta. Please imagine what would have happened if there were no Vishaka. The legislature took almost 30 or 14 years to come out with the enactment and
at that time which have operated. Same is the true with the judgment of the Supreme Court holding that right to education is part of Article 21 and then a long time thereafter Article 21 comes. Talking about Maharashtra, we had a very progressive legislation, which at least I believe it was progressive legislation, that was Bombay Tenants and Agricultural Lands Act 1948, which confers status of owners on the dealers who are actually tilling the land on the dealers' day. Bombay Rent Act 1947. On these two enactments, there are beautiful judgments written upholding the rights of the tenants by Bombay Rent. There is one area on which I always discuss with the students. And why I started discussing with students this area, because in one law school, I was sitting there, one student brought up, he said, why such a long trial was given to Ajmal Kasab? Somebody complained about the bomb blast trial in 1991-92. It took 12 years. So I always told the students that I have myself said that I have myself been a critic of the system, but please consider one thing. Our system gave a very fair trial even Ajmal Kasab for his Article 21. I don't think any other country, neighboring country would have done that. Mr. Venkateswaran, we know that a very seasoned lawyer was appointed for the confirmation case and Supreme Court also did the same thing. A lot of critics criticized that 1991 Bombay blast judgment took 12 years. We see the record of the case. During the tendency of trial, police went on investigating, went on arresting accused. Accused were arrested. Every time the judge had to set the clock back, he recorded all constitutional witnesses so that the newly arrested accused can really cross-examine those witnesses. The enormity of the trial, only one instance I will tell you. The statements of the accused recorded under section 313 of CRPC ran into more than 6,000 pages. The order of those statements, the court has to record what exactly is the evidence against each individual accused. So preparation of these statements must have taken months. And all of us know that when it was under Tara, so appeal was maintained by the Supreme Court, it required full railway working to carry the record. So one aspect you must also remember, see what actually transpires in our criminal court, what happens in trial court. Of course, it's a matter of great criticism. But procedurally, we have a system in place which can give a fair trial. There are judgments, very recent judgments Supreme Court, that even a statement of the accused in 330 is not properly recorded. Entire evidence is not put to him. That may be ground of acquittal, because after long delay, case can't go back. And one more thing which I want to say about high courts. Please study the orders passed by the high courts in COVID days. I am not talking about Supreme Court. Kind of orders which were passed, where there was protection to transgenders, protection to young students who are getting midday meal. So please imagine if these orders were not passed in COVID days by all those high courts, what would happen? And now I come to the topic where we have gone wrong. About that also there are different perspectives. But somehow I feel I am going to talk about liberty issues under Article 21, the environmental issues, but which later. So where we have gone wrong? I think when we discuss this, one fundamental mistake which all of us committed. There are very elderly people sitting here. You must have read news reports about various conferences, complaints made by the lawyers. So whenever there was a discussion about legal system, we discussed with the Supreme Court and High Court. Unfortunately, very rarely we discussed our trial and state courts. And I think when discussion used to take place about where and why, where judiciary is going wrong, or what are the system, we talk superficially. Somebody always talked about long vacations taken by the judges. Somebody talked about not declaring their assets. Somebody talked about micromanaging the High Court. It is now unfortunately happening. That why judges are taking more than 3 months to pronounce judgments without realizing that judges, like Bombay High Court, judges do 150 cases every day. And there are cases where record runs into thousands of cases. You are not expected to deliver judgments in 3 months. Now, micromanagement to some extent that after the pass order to take in a particular time, you must upload those orders. My view was slightly different. In fact, I was criticized by the members of the bar that my orders never used to be available immediately on the website. But my policy was that I will take the risk of delaying the orders, but I will try to learn more and more matters. Because it's a matter of time that you get the orders. So, all superficial discussion, there is going on meditation and all sorts of things. But I think first thing which we overlook, which I have again said repeatedly when as a judge, that failure of our system to give importance to our trial courts. Please look at the powers of a civil judge from judicial magistrate first class. If we had revamped these courts, what are the powers? Please imagine. Now there are series of judgments that under Article 22, as soon as person is arrested, he must be punished with grounds of arrest. And now, I think Shah was one step right, says that that is judgment is prospective, that this is Augustine Mercy judgment, that 2 hours before he is produced before the magistrate for the first time, for he must get ground for arrest. Now, the judicial magistrate who gives the remand has power to say that the arrest is illegal because there is non-compliance with Article 22. Act is not produced before, within a span of 24 hours, so there are vast powers. And somebody must study, in fact, some kind of study undertaken by some institution in 2007, which indicated that because we have 2 tier system, the civil judges, magistrates, and then session judges, district judges, appeals tribunals, that large number of litigants, for social reasons, economic reasons, whatever reasons, those who do not succeed in these courts, they don't go to the higher court. Somebody must make a very detailed study. And what we perhaps committed mistake was always branding these courts as lower courts, subordinate courts, without realizing one thing. I remember when I attended a workshop. And the point which I am telling you, I did not get, that was way back in 2007, where some speakers continue to refer to the High Court and Supreme Court as constitutional courts. Then I suddenly realized one day, read Article 230 Congress, they deal with appointment of district judges, conditions of service of civil judges. So, in a sense, after Constitution, you can't say that only High Court and Supreme Court are constitutional courts, but all these courts at grassroots level, they are also the constitutional courts because they work under the constitution, their foundation. So we kept on branding them lower courts, lawyers appearing in lower court, as if lawyers appearing in the higher court like High Court and Supreme Court is superior to lawyers appearing in higher courts. So, because please remember, we did not have time to go deep into it. Only the factors are available. Some widow is fighting for a share in undivided share in half acre of agricultural land. Some small disputes over money, property disputes, partition disputes, matrimonial disputes. I am going to deal with matrimonial disputes. Somebody fighting for maintenance. These are all matters, common land matters. The trials, the bail applications, all covered by these courts. And I'll come to that, how we have neglected these courts. Another important issue, which again has some nexus, because we always talk about what we call it as huge areas, docket exposure. When we sit in the court and we discuss, how that 498 of IPC is being misused by women, we sometimes say how that SC and SC Act is being misused, because certainly those cases come before the court. But having worked as chairperson of the Legal Services Authority, I have gone to legal aid camps, I have seen the situation at grassroots level. Fortunately, as a lawyer, I had opportunity to work The problem there is that still there are large number of citizens, large number of women who suffer injustice, who suffer violence, but they, the social and many other reasons, they don't complain. So when we talk about delays and docket exclusion, we must also remember docket exclusion because that is where our society has not made progress. There are people who suffer silently and injustice related to them. It's a fact. And we have legal aid machinery. We have legal aid machinery under the Legal Services Authority Act. But there are limitations to that machinery because there is not enough manpower. We don't have that kind of legal aid machinery moving from place to place in villages and we find out whether there are any offences committed so that FIRs can be registered. Our legal aid machinery remains confined to somebody appearing as a remand lawyer and accused goes for remand, or somebody going to jail and drafting appeals and bail applications, etc. Of course, one effort was made by Bombay, as Mr. Veer Desai may be aware. There was a case for some nuclear power plant to various states, and their legal service authority was appointed to oversee the rehabilitation, and rehabilitation could not happen properly. Their legal service authority played some role. Pandemic also some states role was played. So when we discuss what is wrong with our legal system, we have to also consider the grassroots level situation. We decided talked about that POCSO case which we decided. But that POCSO case for me was an eye-opener about how our society functions. And maybe little divergence is the base this topic I am different. And this happens in many cases. Some 13 or 14 years old girl, she became pregnant. And the problem in that case is that her parents deserted her, the society deserted her, there was nobody to support her, and therefore she had no option, no choice but to go and stay with the accused. Please read those judgments, there are two judgments operating. So she was without any support. So the principle which I heard is there was no opportunity to that young girl who suffered such a horrible offense to make informed choice about how she is going to lead her future life. Of course, things are better. She is taking education. Government has provided her better facilities, and that's different. But when we consider failure of legal system somewhere, we have to also consider the one society where we are lacking. Because ultimately, it's not only justice rendered through court. It's about access to justice also. It's about how the society treats the victims of that, the victims of the offense. Now let us come to the trial course. I am generally talking about pan-India picture. Please visit, most of you must be visiting magistrates court in Mumbai. 100 cases, 150 cases every day. I expected new criminal procedure court to bring in some reform because if you go to that court, you will find about 100, 150 cases are there. I think 30-40% are under 138 of the Negotiable Instruments Act, check bouncing cases, many cases under the Domestic Violence Act, maintenance cases under Section 125, and criminal matters. Huge amount of time is wasted on the judges in recording attendance of the accused because accused are on bail, they have additional to attend the court every day. I always felt, as I said one of the order, that now we must actually involve something that we should grant exemption from appearance unless case is for effective hearing. So much of time is wasted on the magistrates on that. And you see, just imagine these young judges who sit here. Day after day, we do 100 cases, 150 cases. And very few people know these young judges, they get 6 holidays, second and fourth Saturdays and 4 Sundays. Out of those 6 holidays, at least 3 they spent in attending legal aid workshops, workshops conducted by guardian judges, local adults, etc. They are all young judges having young family. And this is the kind of pressure of work, there is a pressure of work. And so what happens is, day after day, if you deal 100 cases, 150 cases, you develop a mechanical approach. And then there is hardly scope for innovations. Now, why this is happening? This is happening because we have only inadequate judge to population ratio. I have said this from the top of my voice, I said it in my judgments, I said it in the constitutional judgment, that In 2002, Supreme Court passed an order directing that the 5-year judge to population ratio in India should be 50. This was in 2002. Today we are studying at 22 or 23. Then how do you expect the grassroots levels? These are common man. So I have repeatedly keep on saying, how do you expect these courts to perform? And then we always talk about Vikasit Bharat. We give examples of so many developed countries and say what kind of robust legal network they have. When we ignore that some countries, their names are taken, they have just a population ratio of 100, 113, 90, 80, and all those figures we find in 2002 reported later on the Supreme Court. Today we are studying at 22 and 23. Meanwhile, please imagine what has happened. Large number of new cases have come up. Cases under the Negotiable Instruments Act, Domestic Violence Act, Matrimonial Litigations Act, and talk about it. This is one category of litigation which is going to affect or is already affecting our judiciary. So, this is the first thing has to be done. There was order passed by Justice Oka and he appointed Professor Mohan Gopal to work out a formula how many should be the ideal number of judges in every state. So, there was direction of Supreme Court in 2016 that adopt that formula and make a calculation of just 10 required in trial and district courts and submit a proposal to the government. I was chairperson of the committee, if I am not wrong. He made a conservative estimate looking to the approach of the government. So he said we require some 8,000 and more judges for the trial court in Maharashtra. And I told only some 800 posts have been sanctioned. Now, who is going to ask these questions? And nobody is asking these questions. How do you expect the system to perform when minimum number of judges are not there? It's not about judges. Please go to some of the posts in Maharashtra. Pune, for example, there are senior civil judges posts, 2 or 3 posts. They have unlimited jurisdiction, like judges on the original side. Now they have small rooms before court hours and after court hours. The rooms become their chambers, and during court hours they are in court house. There is no place for litigants to sit. Compare for classic example and diverting the name. This is only one network in the entire country where the litigant wants to come by two-wheeler in a moped or a bicycle. He has no place to park that vehicle inside the compound. He has to park in far away place. We are always talking about from the litigant's point of view. So therefore, how do we achieve the progress in our legal system? But please understand one thing. Those who are entitled to pay must get paid in sessions court or magistrates court. They can't be forced to spend more, engage costly lawyers in High Court and Supreme Court and fight for the bail. So this is one area, and please remember one thing: we need good infrastructure. We need good infrastructure. It's not that you appoint judges in duty, it has happened. In duty, because of a demand, the government passed an order creating more courts. But no judges could be appointed because there are no courtrooms. There is no infrastructure. So, this is one area where we have to really struggle hard to get judges appointed. Those who are practicing Bombay, they remember Justice Oka created a special bench of infrastructural, support infrastructure matters where we have to lay down a law that right to have infrastructure, and it's a government's obligation to provide infrastructure to the court. I always give example of Sangli District Court. The court was in shambles, so there was a proposal to construct 2 towers, one administrative tower, one judicial wing. Government rejected the proposal for administrative wing, sanctioned proposal for judicial wing. And we have to issue a rate of mandamus. And the supervision of court about 10 to 15 court complexes were constructed. So this is actually one area that we are lagging far behind. And somebody must make a study how many litigants afford to carry their matters up to High Court and so on. The second area where I feel, where again I may be wrong, that we know that we have huge tendency. I'll come to that. Why people have to approach the court? I'll come to that. Especially Red Court. I have seen those kinds of litigation where the issues we need to resolve at the level of some section officer of the government, people have engaged lawyers and filed which cases should be given priority. One notification was issued by Supreme Court that please give priority to litigations of all senior citizens. According to me, I said so in one of my orders of this. Completely wrong. Now in Bombay High Court, we have second appeals where third generation of litigants are the parties. Now should we give priority to a case, a new case where 60 years old man is there or woman is there? Or should we give priority to those cases where third generation of litigants is possible in a case? Same thing applies to family court matters. Sometimes before me, lawyers used to apply, sir, in family court, my client is more than 60 years old. I should tell them, look, there are cases of somebody who is in 30s and 40s. They must be given priority. Now, under trials cases, no doubt they should be given priority. But two areas that I have commented upon. One is because we don't know what kind of litigation we have. We have common mass litigation. We have litigation of laborers, we have litigation of workers, teachers and whatnot. Was it necessary to have a commercial court at any Indian situation and to say that give priority to the commercial court at litigation? And there is some procedure there that under section 12A, you have to go for compulsory conciliation, mediation or conciliation. And then, even on that, there are petitions filed, rejection of claim, etc. So, was it necessary in Indian situation to give priority to commercial matters? Because talking in Indian context, see, when I am part of the judiciary, I am not concerned with India's ranking in World Bank or some international organization. I am concerned with dealing with litigations of deserving litigants. So, I always wonder, we talk about commercial litigation. Unfortunately, I may also use that phrase. But maybe I have heard it this way. How commerce can be associated with litigation? Here is a question of commercial litigation. And as a part of that, 138 of Commercial Instruments Act, purely civil wrong. Purely civil wrong that we are converting into a criminal law. And please someday somebody must study those complaints filed in the Commercial Instruments Act. There are so many complaints which I came across which are actually made for recovery of unaccounted money. Because the moment check is dishonored and aggregate position check is issued by the account holder, there are presumptions. So was there any justification for the legislature to enact section 138 and please go to any magistrate court in any university? The courts are crowded with cases under 138. And what take the backseat are dispute arising out of matrimonial matters, offences, magistrate tribal offences. There are also some of the offences are very serious offences where there are victims of the offences. Maybe in some cases, when a person is on jail, only because the cases remain pending, they face so many restrictions. So that's area only some debate is required whether in Indian condition we should give priority to commercial matters. Secondly, under the Arbitration Act, there are provisions that priority should be given to section 34 petitions or section 37 petitions, 37 appeals. Now, mostly these arbitration disputes, firstly, they are in the connection with government contracts, and otherwise, they are all arising out of commercial contracts. Disputes between two entertainers who are otherwise well off. So, can our system afford to give priority to arbitration matters? Of course, that's not the reason I am not in arbitration. I graduated after occupying highest office. I should not be in adjudicated work. And in advocate, I always say that 22 years of justice, I was tired of hearing lawyers, so no more hearing of lawyers. But still, how much importance can be given to section 34 and section 9 petitions? Now, these are the issues which we require application of mind. And these are the issues which are very, very relevant to the problem which you are facing. That courts are not able to perform their duty. They are not able to fulfill the expectations of common man. So, I always give a classic example. I'll come to that later. One issue which I want to highlight. As said so in the Constitutional Bench. as a lawyer, as a judge, I have seen one thing that people sitting in the High Court, telling the trial court, decide this case within 3 months, decide that case within 6 months. People sitting in the Supreme Court telling the High Court, here the and decide the matter on the same day. So what happens is, see there is a hospital in suburbs, and it had very big industrial family, and for I don't know for how long, 25 years, disputes are going on in city civil court, magistrates court, charity commissioner's office. So as a judge, I have always found that whenever that dispute goes to go to Supreme Court, case goes to come on in a time bound schedule, decided in 3 months, decided in 6 months. I said so in the judgment, therefore I am saying it. See, this kind of thing sends, one thing sends wrong signal that somebody can afford to go to higher court. He comes back with an order so that his case gets priority. That is one part, I have an academic part of it. Some boys are practicing sessions court. Every session judge is doing criminal matters in state court judge. You will find that he has 30, 25, 40 time-bound cases. What I feel is that when we sit in the higher court, we don't know the grassroots level situation in a particular court in which case is mentioned. I feel that what is all this appeal, this criminal appeal in the sessions court is of 2010. So decided in 6 months, but I don't know that in that court there are 2005 appeals pending. So I gave you 1 point of voice sitting in the higher court. Therefore, in constitutional bench judgment, we have said that no higher court can do that. Because as far as priorities are concerned, they have to be left to the concerned judges. They only know what is the kind of tendency in those courts. Because, and again, I said, it sends wrong signals that if you can afford to go to higher court, you come out with a favorable order to get out of turn priority to your case. And there, the question again arises of priorities. So, is it correct for higher court to say that because one case goes to them, should be decided on priority basis? It happens in bail applications. Sometimes we judges feel there is no responding case for bail, but I satisfy the lawyer by saying that decide the case within 6 months. And I don't know whether charge is framed, because unless charge is framed, trial can't start. But I give the psychological satisfaction to the lawyer without realizing that in that particular sessions court, there may be 10, 15 years old older trials. So this is where they are going wrong. Now, why cases pile up? Why there are more and more cases? I want to tell you. I sat extensively Aurangabad bench in 2012 for 8 times. What kind of cases people have to come to the court? Please understand this. And these cases actually deserve priority. I don't know what is the position. I read it as a lawyer and a judge also. We have teachers who work in aided schools, primary teachers, secondary teachers. And what happens is, especially in case of women teachers, they go on migrating from one place to another, so leave one job, go to other aided school. And there are gaps in the service, breaks in the service. So there was some kind of government resolution that 3 breaks can be controlled by the officer of the deputy director level. And 3 more breaks are there, they can be controlled by director. Unless teachers used to come to report, nobody should get that leave. So many cases people have approached the court for pension. You can find so many cases where people go to the court for retirement. They are all small people. Now, unless they go to the court, you don't get relief. In Karnataka, I saw a unique phenomenon. So a small person, he saves something from his service or from his occupation, goes and buys a small piece of land. Now, there is a land renewal act there, not a court land renewal act there, which mandates that the moment there is a register secretary, name has to be entered in the regular records, because person uses his life savings, purchases a land, he gets that kind of satisfaction. I acquired property in the age of 60, 65. But he has to go to read court to get his name added in the regular record. So if you don't have your name in the regular record, you can't enjoy the property. So many cases where people are forced to go to the court because they don't get justice at the hands of the executive. Now, this is one reason I talked about girls, victims of not getting support from the society. But these are cases we can avoid it. In Supreme Court, I found, those members of the armed forces who suffer disability in service, they are entitled to disability pension, so they go to armed forces as well. They get pension, but in the order comes to the Supreme Court. So I used to ask additional solicitor general, what is all this? These people work in army, and for technical reason they get some disability pension, they are coming to the Supreme Court. They are being very loyal. Other classic case which I remember in Supreme Court, that reservation for persons with disabilities. Reservation was not imposed. In fact, some of the matters I remember, people had appeared for civil service exams, so we had exercised power under 142, and we said, whichever railway service, whichever their service, give them employment. Don't give them packages. And these matters would have been sorted out there, after all, people with disabilities. So, one reason why our system is crumbling under pressure is these kind of litigations. One more classic example, I think Mr. Veer decided for. I wrote an article in one of the leading Marathi newspapers and said that, they are suffering because of wrong concept of development. Building metros and bridges and roads is not development, it's all infrastructure roads. And Bombay, come to Bombay, and in the bigger city for the country. Take a case of somebody who is employed, say, in small district in Maharashtra, getting salary of some 40-45 rupees, is transferred to Mumbai. He cannot afford to have legal accommodation in Mumbai. He cannot afford to have. He has to go to some illegally constructed slum, stay there, pay very high rent. This is because there is no concept of affordable housing in our cities. And the moment you start constructing illegal structures, there are a number of litigations. People have, Mr. Desai referred to a case where the issue was whether people staying in unauthorized slums are entitled to water as a matter of right. We said Article 21 comes right to shelter, right to water, so long as they are staying there. So these kinds of social situations create litigation. Please find out from the courts in Bombay how many cases come to the court because of these slum areas. And unless we have affordable housing, we won't be able to stop this. Where people will live. Same case which Mr. Veer Desai referred, there was statistics based on record that 27% of the police constables stay in unauthorized structures in Mumbai. So there is no housing for police. It's a matter of record, official record was produced. And one more area where our system is coming is matrimonial disputes. Matrimonial disputes are on the rise. Now, one matrimonial dispute creates 5 grassroots level litigations. Maybe 125 CR this week, Hindu Marriage Act or Special Marriage Act, Domestic Violence Act. Unfortunately, there are child and custody issues. So now, matrimonial litigations are rising. Every matrimonial litigation has potential to take 5 different grassroots level litigations. In those applications, revision applications, special petitions, appeals, and whatnot of the Supreme Court. Now, we don't have robust machinery in our society where before people go to the court, there can be some kind of either reconciliation or golden handshake, parties separate by arriving at certain terms. Please look at the situation of family courts. There was such a fantastic idea about family courts. Some of you must have attended the groundbreaking ceremony of new airport complex in 24. I always call it the first groundbreaking ceremony, but there was one more ceremony in last year. So in first groundbreaking ceremony, there was Chief Minister, Deputy Chief Minister. So I said, sir, it's a good idea. It was my judgment that you land to the airport complex. So I have to say that it's a good step taken by the government. And still, 50% of land is not given by the government. That's not the subject today. I said that when we are celebrating this event today, at a very short distance in Bandra, where the first family court in Maharashtra was established. Additional building of the family court is under construction for 8 years. There are only 7 judges in the family court right from 2005. But I don't know. I am not sure that the construction is complete even today. Now in Bombay, family court got 7 judges and litigation has multiplied during the last 20 years. There are many lawyers who appear in these matters. So they may be aware. Again, this is a classic case of neglect of grassroots level courts. Now that is where I think now we have to set our priorities right. Then I talked about environmental matters, the landmark judgments of the Supreme Court, etc. When it comes to duties of the court, one category of cases is Article 21 violations, liberty matters, which involve not only denial of bail but also cases where people are being penalized or prosecuted based on speech violation of Article 91. They are all liberty matters. And I always say that when environmental matters are liberty matters, because right to have pollution-free atmosphere is a right guaranteed in Article 21. Associated with MC Mehta last 2 years and he engaged in the meeting in October, etc. One lawyer got up and he said, sir, this is all Elites business. You are talking about pollution in Delhi, 400 GPR. I said, no. Elites people, they can afford to have those machines in their house, air purifiers. But in Delhi, majority of population, it works on the streets. Somebody works as a police, somebody has some food stall, somebody works as an auto rickshaw driver. I said, these are the people who suffer because of pollution. And in fact, there are statistics available in the public hospitals who are suffering from lung diseases, not people who stay in comfortable houses, but people who are on the street. So these are also Article 21 pollution issues. I met certain activists last year in one of the conferences in Delhi. They said, sir, you are talking about Delhi because population not far behind. So far, Mumbai is saving because of speeds, but we don't know what will happen after 2 years. So, they are liberty matters. If you cut 45,000 mangroves, they become liberty matters because we don't know how devastating will be the effect which will be felt maybe after 6 years or 10 years. Now, problem with liberty matters, like bail, is that in deserving cases, when magistrate tribunal cases, people don't get bail. I am not here to justify what is happening in the trial courts. But please remember what kind of attack judges face those who grant bail on the social media. On the social media, there are so many complaints filed to the High Court. See, when I became a judge, people used to discreetly file complaints against us by sending it to the Chief Justice of India, Chief Justice of Bombay. Now, if any complaint is filed against our trial court judges, first copy is delivered in the chamber of the judge or at the residence of the judge. So all sorts of allegations which are made against judges must be read by his family members also. 90% of complaints are frivolous, 10% may be illegal. So, whatever reason, that reason we have to combat. That why deserving cases where people don't get bail in the trial courts. Why deserving cases where, say, case for acquittal, people are not granted acquittal. What are the reasons we must find out? Because this also leads to a situation where our legal systems fail because ultimately a client who ought to have been released on bail, say by a magistrate in magistrate tribunal case, he has to travel up to Supreme Court. You are adding to the pendency, artificial pendency. And quite honestly, somebody says now there are inconsistent reports. There are so many judgments about violation of Article 22(1). Failure to furnish grounds of arrest, but whereas the approach of the courts is inconsistent. Same is the case with law attorney Najib's case, Article 21. Actually, that law is so simple that in those cases where there are no prospects of trial commencing, huge number of witnesses, and the person in jail, non-incarceration term, which we have to necessarily consider in the context of maximum sentence. So, the basic concept in Article 21 is that pre-trial or pre-trial incarceration can't be converted into punishment, and therefore Najib and series of judgments. Now, question is how many high courts are following your judgments? And of course, you can criticize that some judges, the Supreme Court are not following. In one case, it happened in Delhi. So, please remember that this jurisprudence is still evolving. 5 years back, there were no major judgments on the issue of grounds of arrest. Now there are judgments in the last 5 years. And therefore, sometimes I always say to young law students that don't think so negatively. At least there are progressive judgments on grounds of arrest in the last 5 years. They are not there earlier. But these are the judgments of the Supreme Court. The question is how many high courts follow, how many high courts follow those judgments. Same is the case with freedom of speech violations. Those Supreme Court judgment even refers to stand-up comedians. Question is why the stand-up comedian could not get complete relief from the Bombay High Court. So these are the issues. These are the issues, and environmental matters. Whether are we taking some other path in the system, which what happened in Godavari and in Singapore, and so many judgments. That's the issue. Same is the case with demolition cases. When there are actions of demolition taken, I remember a case in pandemic when lockdown was going on. Certain birds were demolished. Nobody knew who demolished it. So we have to take very strict action against them. So these are the cases put get flooded, and all these cases raise very important issue of Article 21. If people construct illegal structures, stay there, maybe for 40 years, 50 years. Of course, the structures are illegal. I am saying this in the one case from other money. Number of structures there, for 50 years structures are there. Now the issue before the Supreme Court is whether they should be rehabilitated as a matter of right, or it should be just by mercy. Now if you speak, I am not talking about commercial premises. I don't think we should. Case is different. People stay for 50 years. Of course, they stay on lands which are earmarked for railways or some public project. But in these cases, why should people approach the court? Why can't state apply Article 21, right to shelter, and say that all right, you are not illegally constructed structures, but we will rehabilitate it. They are in a decent manner. Not like Mowing, where they are rehabilitated in the area where there was maximum pollution. But why state can't take that stand? And of course, why courts can't take that stand? That is the question many of you will ask me. That if state is not taking stand, what prevents the courts from taking that stand? So, these are the cases which are coming in large numbers, and we are not able to deal with those kind of cases. Look at what happens in leading backwards, 100 cases, 150 cases every day. So already I talked about listing, lack of transparency in the roster of the Supreme Court, etc. That's a different part. And again, these are matters where we need to work. There is no fixed roster in Supreme Court. Some subjects commonly assigned to many benches, so at some level somebody decide which case will go to which court. It's not like I court that today I file a bail application. I know that it will go for court number so and so. That's not there. So even in those areas there are huge challenges. Because when we talk about listing, it has direct connection with transparency in judicial. Whether there is transparency in listing. So there are questions and questions. I don't know how many of you have read books written on party scheme by Dr. Anil Sir, great author. And these books actually, what he said was eye-opener, what happens in the society. He has talked about drug addicts. He has written a beautiful book on Purnia in Bihar. What kind of situation was there in Purnia when he went there with some social workers. The point is, he has written a beautiful book. The title of that book is Prashna and Prashna. So questions and questions. So this is what happens in case of our judicial system. And therefore, actually, when we analyze the whole scenario, so many unanswered questions are there, so many areas, especially trial courts, we are lacking for. And last thing, which I think I already said about listing policy, priorities, which cases should be given priority, etc. Another important issue is about appointments in the High Court. In last April, the entire political system is on the website. that how the High Court College suggests the name, what is the format, the Chief Minister gets his name, what is the format of highway reports, what is the format of views expressed by the Government of India, how they are placed before the college. One major parliament system is after Supreme Court Parliament recommends the name, good candidates have to wait for 1 year, 1.5 years. And I have always said that transparency has to be in collegium system. By publishing resolutions, you don't bring about transparency. Sometimes you compromise on privacy of the candidate. And what happens? Not in Bombay, but at other places, I see in Calcutta, once the name appears in the collegium resolution, workflow completely stops. And a candidate is in the age group of 45 or 50. He needs money, he has a growing family, and 9 months, 10 months, he has to simply wait. We talk about transparency. Now, Supreme Court has become transparent. They have explained what is the procedure in college. But nobody knows what is the procedure followed after Supreme Court college recommends. Who takes the decision? Why matters are kept pending? One classic case from Karnataka, I'll say, and I stop. I persuaded a young lawyer, a very brilliant lawyer, just about 45, I said, he was a judge, and everybody in the bar, whom I said, he said, no, this man is doing about a transformation. So his name was recommended, approved by Supreme Court, reiterated by Supreme Court College. Ultimately, he waits for 1.5 years and says, sorry, I will withdraw my consent. And the gentleman used to appear before me every day, of course, he would be successful lawyer in Supreme Court. So I will always used to have regret that this man should not be standing in front of judges, but he should have been sitting somewhere else. But this also is a very important area because these leaders, Justice Oka said it openly in Bangalore, that why competent lawyers are not willing to give consent to become High Court judges. So this is also one area because when we want quality justice, we want quality judges also. And if we don't have a system which will give us quality judges, that will reflect on the performance of the judiciary. So I will close by saying, of course, I began by saying that there are certain areas where judiciary has done well, and you can't deny that. Even today, we get some judgments which give us a hope. I remember the read judgment, after the Murtali judgment, I think next day, the judgment by other coordinate bench in no uncertain terms. It reaffirmed Najib, it reaffirmed all successful judgments and mentioned here in Article 21. So there is a hope, not that all judges are bad, not that all judges are not performing. Some of the orders you see, orders of discharge or any orders passed by trial courts or sessions courts, they are very encouraging. But what I am giving you is a picture where we come to the conclusion that the judiciary is not able to fulfill expectations of common man from the judiciary under the Constitution of India. So this is just overview. And idea of saying this, as I began by saying that I may be completely wrong in what I say. Idea of this discussion is that we must try to find out what are the real issues, not those issues by less around vacation and all other things. Without knowing that we take names of some countries, there are no tendency. But find out how many days the Constitution could judges work. That's a different topic, I am not on that. But we must find out real reasons. The emphasis is on finding real reasons. And ultimately, this is one forum, UCL, which has done so much for the cause of justice. Now, this debate has to be started that where exactly we need improvements in the judiciary and what exactly we need to do to make our trial judiciary very robust, effective, and very bold. I thank all of you for giving me this opportunity. Idea is to set a thought process in motion, and I hope that this will be carried forward by all those great activists who are sitting here. Thank you.
Thank you, Justice Oka, for a very, very transparent lecture. Talked about problems with the judiciary and also some of the positives. We have very little time, but we can take about 3 or 4 questions. I will take those 3-4 questions together. Request Justice Oka to answer them. One by one, we will answer. One by one? You will get a yes, first. Yeah. Just identify yourself then.
Sure.
And make it brief as well. Yes.
Thank you, sir, for raising up your presence. So, I particularly want to talk about environmental matters and regarding the 45,000 mangroves record judgment. And basically, I mean, everybody here, and you know about what is happening. In a scenario where the judgment talks about having judicial restraint, leaving technical and policy determination to the domain of competent authorities, and where the court has not done any assessment, where it has sort of laid down a tradition that if the execution has taken a well-informed decision or not, then the court has no need to interfere. My question is that in these sort of big-scale infrastructure projects, which are termed as projects of public importance, what is the basis of courts to decide whether there is a need to interfere or not? And whether the courts should have employed any technical authorities, because then how can the court even make a decision on giving an approval?
I'll answer this question very quickly. One, mangroves form part of the forest. No doubt about that question, because after compared to the species that they redirected part of the the approach is for adopted in Karnataka and even MC method cases. That there is a public project. Right? What needs to be done is somebody, some impartial agency, third party is considering our experts. They must examine the alignment of the project. They must understand what exactly they want to do. I think I'm a lay person in that. They will have very close pillars on that most of the road address as we see ceiling. So somebody should have been appointed. I believe that was argument, one of the arguments was Supreme Court. Please find out whether it is necessary to cut all these manual logs for and in Karnataka, this was the approach. We found the authority not functioning. So a committee of experts, they don't want experts that are appointed. So every time for metro, for a road or for any project, the process we followed was that the permission authority will go to that committee of experts. Experts will go on the site. We did not confer their deliberation to change the alignment, but they will examine the alignment. And they will say how many trees are really required to be cut, or else some trees can be translocated. In CEC, the import CEC will also suggest in Supreme Court. They will also do the same job, how many trees can be saved, and which trees can be translocated, where trees can be planted. And in Supreme Court, in fact, those orders you will see last 6 months, we said, will not permit cutting unless first there will be compensated forest too. So this kind of exercise was, I have not read the Bombay High Court judgment. This kind of exercise was not done. If this exercise would have been done, from my experience, I tell you, in Bangalore, if you have practically every case that we sent there, issued to the committee, we could save 25-30% of the trees. Right? So that approach needed to be adopted. I think in this area. Of course, there are larger issues that other issues are also there in the world. Of course, they took permission under Section 2. I don't know. They must have taken permission under Section 2. Another question is, one sentence in the judgment of the Bombay Court that mangroves should not be discontinued, but in extraordinary cases they can come to the court for permission. What is the scope of that sentence? So, to cut the point short, this exercise should have been done, and I am sure this exercise would have been done. Large number of mangroves would have been saved. And another issue where there is, can there be plantation of mangroves? Can mangroves survive? Yeah, I'm not a botanist. I'm an expert. If you artificial plant of mangroves will go. So that issue also needed justice. Maybe, as I said, I'm eternal optimist. Maybe after a few years that will change our view. We'll be able to say mangroves was modified. Static.
Myself, Advocate Ibrahim, I'm practicing there. My question is that recently using of UAP against the lawyers, recently the government in 2022, one organization has been banned and out entire country more than 95 lawyers has been declared as an accused because they were providing a legal aid. So how to tackle this? Because the allegation when I appeared in the matter as a lawyer in Bombay, the allegation was that he appeared for those in a court. That's why he is an accused. So how to tackle this? This is one of the recent problems.
Unfortunately, I have not read anything about it. I can't imagine this happening that why I think for UAP accused. But this needs to be tested in the court. Be seriously tested.
Sir, even my junior has been accused.
This needs to be tested and it will affect. It is not only affecting legal profession. It will ultimately lead to affecting right to defend under Article 21.
Exactly.
Because you are declaring lawyers from appealing. But that needs a closer examination. What exactly is the allegation?
Yeah, I'm Shivani. I'm a teacher among the law. You spoke about tendency of cases. What are your views on jury system? Will that help cases faster and reduce the corruption?
I think jury system, if you talk about jury system, it will be a complete violation of principles of fair trial. Jury, they are not trained to appreciate evidence. They are lay persons, they don't know the law. And for good reasons, maybe none of this case, we got rid of jury system. Right? I don't think jury system can be controlled.
So one more quick question. When you said about the say a forest where say what's happening in Sanjay Gandhi, 50 years people have stayed there. So now the courts are looking at what to do with the people. But my question is, can the court actually punish the people responsible to keep the forests intact? Like, how will people get in there? It's never.
Two different aspects. One is a category of citizens who have rights as regards the forest. Their rights to protect it. That is one category. One category is of encroachers, star people. So both the categories are dependent together. There are rights in this sort of forest in case of certain tribal government. That's different.
The courts can punish the forest officers?
So I don't know.
Let's not get into it.
So I just need to know.
Sir, good evening. My name is Advocate Dharmaj Pandit. My question is regarding the Disabilities Act passed by Parliament 2016. I had a case, the victim was a Down syndrome girl. And thanks to Mirror Now, they came to the rescue. The police was refusing to register an offence because the police is unaware. After the media came in, they showed little push-up and did the research and section 9.
What is your question?
My question is, there is, after the FIR was registered, there was no court in Bombay Session Court. So I had to again write to the Chief Justice, I had to write to the Chief Minister, why is there no court? After 9 months, the court was constituted, Court Room number 39 Session Court. And then we need to know that the judges, when I appear as a assistant VP, the judges are not that sensitive because that girl cannot express. There needs to be sensitivity within the police administration and the judiciary, which is lacking. And I feel so bad about it.
One question.
Last question.
Good evening, sir. My name is B.N. Kumar. I run a NGO called Accident Foundation, trying to save your mangroves, your wetlands and etc. You are actually quite really grateful to you for your judgment on protecting the mangroves. But today, your judgment itself, the danger of getting nullified. You already answered the question of 45,000 Oka. Another issue is of the compensatory plantation. I think it's absolutely opposite because for the mangroves that will be cut in, say, Navi Mumbai or Mumbai, I am going to do compensatory plantation in Chandrapur and Jalgaon. And they absolutely no relationship. Here, mangroves are being lost, and I want to plant traditional trees in Jalgaon and Chandrapur. I think that loss needs to be,
Actually, Karnataka encountered this problem, so we actually said that what is the need of complexity of afforestation? A particular area loses the green cover, so that area needs to be compensated. You can't get the distance of 10 kilometers or 100 kilometers. That's important.
Any last question?
Last.
So, good evening, sir. I am a first year clear LLB student from Government College. I have a question regarding the pendency of the courts in and Supreme Court. So, we are living in an age of AI, and people's lives are more and more integrated with IT services. So, are there any reforms on that side with the use of AI plus humans in the loop, whereby the pendency of the courts can be reduced to some?
See, AI has limited use. If you supply the data, AI can create a very nice nonsense for you. But AI can't replace human brain. I'll give you a simple example. If you want to cross-examine witnesses in a criminal trial, you have to study the psychology of those witnesses. They are from which state of society, what is their background, etc. AI is not going to help you there. If you draft a claim, you have to imagine who are going to be your witnesses. AI will not. You have to ask the client that you certain documents to produce, whether attesting witness to those documents will support you. All this AI can't help. AI has limited significance, but please understand, I know that AI includes. This can be constructed used. We translated 36,000 judgments of the Supreme Court in Hindi by using an AI tool, or 12,000 judgments of Supreme Court in Bengali. But AI, when it comes to decision making, can give you very prejudiced and discriminating results. So, limited use, yes, it will prepare a nice comparison for you. It will correct your factual mistakes in your drafting. To that extent, yes. Because even if you not able to find case law, it will create artificial decisions for you by using artificial intelligence.
We will just request one last question from an NGO Parliament committee.
माझं नाव प्रवीण बोरकर आहे. मी पाणी हक्क समिती या ऑर्गनायझेशनचा आहे, संघटनेचा कार्यकर्ता आहे. आपण 2014ला एक जजमेंट दिली आणि त्यातून आज मुंबईला सर्वांसाठी पाणी धोरण अशी एक पॉलिसी मिळाली. तर त्या जजमेंटच्या अनुषंगाने असं म्हणजे नोंदलंय की घराचा पाण्याशी संबंध नाही, त्यांना माणसाला पाणी मिळायला पाहिजे, हे तर धोरण बनलं. पण त्याच्या अंतर्गत काही वेळा त्याचा चुकीचा त्या जजमेंटचा वापर करून घरं तोडली जातात. तर या संदर्भात कसं
निकाल असतो तर आपली परिस्थिती अशी आपल्याकडची त्या निकालाचा गैरवापर होतो. गैरवापर होऊन द्यायचा नाही, हे शेवटी थोडंसं नागरिकांचं पण कर्तव्य असतं. एखाद्या जमिनीचा गैरवापर होत असेल त्याच्याविषयी सुद्धा दाद मागावी लागते. कारण एकदा म्हणजे फ्रँकली स्पीकिंग आज वीर देसाई जेव्हा सांगितलं मला आठवलं की काळा निकाल दिला होता. काळ जेव्हा आम्ही पण विसरून जातो काय निकाल दिले. तर हा प्रश्न असा आहे, हा विस्तृत होत असेल त्याच्याकरता कोणतरी पुढे यायला पाहिजे, थांबायला पाहिजे. कारण कुठली ऑर्डर असते कोर्टाची त्याची एक पोटेन्शियल त्याला असते विस्तृत होईल.
Here to say thank you to all of you, but even more important, thank you to Justice Oka. Because I think what he has done is sort of broaden our horizon in terms of what are the issues which we need to tackle as civil society, activists, lawyers, non-lawyers, and I think there is a lot of thought that we need to give. Probably person like me who is not a lawyer but interested in rights and civil liberties, listen to his recorded speech again. But I think there are many pointers which have come out through his speech, which requires we as lawyers, non-lawyers, as citizens to act upon and move further. Because otherwise all of us get so disappointed by various judgments given by the courts, and particularly the higher courts, that people have started losing faith in judiciary. So at one level we need to figure out ways of trying to get justice back, and we also need to figure out ways in which, and I feel many of, particularly from the younger generation, would feel encouraged by various pointers given by Justice Oka, and it would be really ideal if people organize themselves, even if they did not come to PUCL, but at least in an organized manner, think of strategies in which we can actually make the constitution work in India. Thank you all.
There is tea outside for everyone. Please do have tea. UCL volunteers are requested to go outside.
Sebastian, I not copy